So we would like to discuss the second uh, installment of the lecture on corporate actions and legal liability. So tonight we would like to look at post-incorporation contract. Of course, we look at the pre-incorporation contract, promoters and others in previous class. So now that the company has been formed, under what circumstances can it lawfully enter into a valid transaction, valid contract? So those are the matters that we want to be exploring. And you've already made the point that upon incorporation, the company acquires capacity to enter into a contract or transaction with its officers, agents, and third parties. And this point was made when we were discussing mechanics of incorporation. Yeah, so let's keep that in mind. And just in case you have forgotten, go back to section 18, section 18, section 19 of Act 992. Section 18 reminds us that subject to the Companies Act 2019 Act 992 and to any other enactment, a company has full capacity to carry on or undertake any business activity or do any act or enter into any transaction and be full right, powers and privileges for purposes of the thing stated. So what it means simply is that upon being incorporated, the company acquires full legal capacity, just like a natural person, despite the fact that it is a juristic person or an artificial person. And if you look at authors like Seeley and Sarah Washington, they will make the point that a company is a legal person, and the principle which determine the validity of contract between legal persons, of course, as we know already from law of contract, apply to companies as well. So, and remember that a contract is valid and binding on the company. And let's pay attention to this. It is valid and binding on the company only if, one, the company has the capacity to contract, or the law deems the company or presume the company to have that capacity. And two, agents effecting the transaction on behalf of the company have rare or apparent authority, that is actual or ostensible authority to do so, or are deemed or presumed to have that authority. So when these conditions are present, then we can safely say that the company can enter into a valid transaction. The company can enter into a valid contract. So let us keep that in mind. So as we have indicated, the company itself, that is the company itself must have the capacity. The company itself must have capacity. And if the company certainly is acting by agents, officers, and so on, then they too must have authority to represent the company. And this authority may be actual authority, that is real authority, or apparent authority, or what you call like the ostensible authority, as it were. So as we have stated today, the company has capacity and powers of a natural person to undertake actions and other transactions. So section 18.1, we've already cited it today, is quite instructive on the fact that the company has a full capacity to carry on undertake any business or activity which any normal person can enter into as it were. And for that matter, the company also can acquire rights, assume responsibilities or obligations under such a contract or such transaction. And Section 19 is quite instructive that a company's capacity will not be vitiated merely because it has acted beyond its stipulated objects of business, in respect of which it was incorporated. So if we look at the Section 19(1), for example, I quote, where the registered constitution of a company sets out the nature of business or objects of the company, there is deemed to be a restriction in the registered business on the business or activities in which the company may engage, unless the registered constitution expressly provides otherwise. So we have noted that under the new dispensation, under the new Companies Act, it's not mandatory for the company to have a registered constitution and get an object clause, that is, state the nature of business for which the company can pursue. On the other hand, where the company chooses to adopt one and go a step further of expressly stating that the company is supposed to do XYZ type of business, then the rule is that the company ordinarily cannot enter into transaction outside the scope of what has been stated in this constitution. So that is a general rule. In absence of that, the company can actually state otherwise, that regardless of what we have stated, the company, and for that matter, those who represent the company, can go outside the scope of this. If that is stated explicitly, then the default provision we have in Section 19 will not apply, as it were. So let us keep that in mind. But if you look at the 19(2), as we have said, that where the company's constitution has even provided for restriction on the business activities in which the company may engage, it is a law that the capacity and the powers of the company shall not be affected by that transaction. So merely because you have a restriction in your your constitution per se, is not going to affect the company's capacity, generally speaking. The company will incur contractual liability to a person if the officer or agents of the company had authority, actual or ostensible, to enter into the contract on behalf of the company. So we have already seen in previous classes, and also following Lord Cranworth's observation in Aberdeen Railways against the Blackie brothers, that the company does not have leg, does not have hands, does not have eye, does not have any of the human features. So the company functions through the agency or the instrumentality of a rare human beings. So when can we say that the actions of those human beings who actually represented the company in transaction are actually treated as acts of the company? So that is the point we are making, that yes, if the officers or agents had actual authority or sensible authority to enter into the contract or the transaction, whatever liability which arises from that transaction will be a liability for the company. So I invite all of you to read in detail section 144, section 146, section 147, and section 148 of the Companies Act 2019. You notice we'll be discussing some of them in our previous class, so let us keep that in mind. Will somebody volunteer to, but will somebody volunteer to read, but it will take time. Otherwise, we have read section 144 again, but in our previous classes, we read about this. Section 144 speaks to division of power between general meeting and board of directors. That is matters which are reserved for the highest decision-making body of the company called members in general meeting. Shareholders, if it's a company limited by share, when they meet in the general meeting, that's the highest decision-making body. So in terms of section 144, some matters under Act 992 or by the company's own registered constitution may be reserved for the highest decision-making body, meaning that those matters can be decided or can be pursued only at that level. Then we also have matters which can be pursued by the board of directors or people authorized by the board of directors, employees, officers, agents, and so on. Yeah, so those matters are there. And then we also have situation where both members in general meeting and the board of directors are competent to act. Any of them can act on it, so that one is also there. So look at section 144, that is what section 144 actually speaks to. And of course, we have section 145, what we call major transactions. Certain transactions which are so huge in terms of their value or quantum, and special rules are required to be followed, and we need a certain special threshold of majority of members or certain procedures be followed. So look at the section 145. And section 146 permits delegation. The board of directors, for example, can delegate things that they are supposed to do to a subcommittee or even to a managing director to do that which the board of directors could have done. So look at that. And then section 147 speaks to when acts of members in general meeting or acts of board of directors, when carried out in the usual way in the course of business, are considered as acts of the company. And section 147 is really important because it often gives rise to misunderstanding or controversy as whether something which was done by a managing director could, for example, be considered as an action of the company. So that is very important. For example, as in if the managing director, for example, attended, let's say that the birthday celebration of a very hardworking staff, and announced at the birthday celebration that, well, because this staff has distinguished himself or herself so well, he's going to be given a certain number of shares in the company. So this is a managing director making such a promise. So the critical question which will arise is whether such a promise to give shares of the company, for example, made by the managing director can be considered as the managing director having done that in the course or the usual way of business, and for that matter, is binding upon the company. So those are the sort of matters which are dealt with by section 147. And the case of Aussie Air and Wood, the case of Aussie Air and Wood, you've mentioned it before. Aussie Air Limited and Darko against Wood, 2005, 2006, Supreme Court of Ghana Law Report, 1057. When the Supreme Court, the majority opinion and the minority, majority led by Professor Dr. Datiba and then a minority led by Professor Modibo Kran, actually went to town to show when acts of, let's say, managing director can be considered as having it done in the usual course of business, and for that matter, should be treated as acts of the company or not. So I invite all of you to go your law report and read the case of Aussie Air Limited and Darko versus Wood, 2005, 2006, Supreme Court Ghana Law Report 1057. Good. Now we come to what we call the indoor management rule, or the presumption of regularity rule. Now, historically, especially going to English company law, companies attempted to escape contractual or transactional liability by trying to seek refuge under their internal regulation, their internal rules regarding how things should be done. So, where the company was involved in a transaction or contract, and the company was alleged to have defaulted or to have breached an obligation, and the company is, for example, sued or engaged with respect to that, the company, in the past, will look at and say that if you look at our constitutional documents, especially those days when they used to have the dual constitutional document and the English company law, having the memorandum of association and then the articles of association. But as I said, memorandum of association and articles of association are no longer part of our law. So we have moved from that to regulation, and I've moved from regulation to the Constitution. So just a single document. So in those days, they will say that, well, if you look at our constitutional document, it says that transaction like this should be done according to this procedure or should be done this way. And this thing you are accusing us of having breached, that transaction was never concluded according to the stipulated procedure in our constitution. And for that matter, we are sorry, we cannot be held liable or responsible. So that used to be the attitude of companies, in times past. Now, when it happens that way, it certainly leaves the third party, that is the one who entered into the contract with the company, with no rights or remedy, even though the company might have benefited from the transaction or the contract in question. As we have noted, the company will act through its officers. So the company will be saying that, well, this particular officer or this agent who was supposed to have represented us in this transaction actually did not have authority to do what he did. Or even if he did, he didn't follow the prescribed procedure. And for that matter, we don't consider this transaction as a transaction that can be laid at our doorstep. We are sorry. Yes. But the law has moved on. And the law sought to provide protection to third parties through a rule which for a long time was known as the indoor management rule, or the so-called rule in the Tech 1 case, if you've heard about it, or what we call the presumption of regularity rule. Presumption of regularity rule. So if you look at our law, especially section 150, section 150 of the Act 992, we call the presumption of regularity rule. So this indoor management rule had its origin from an old case known as Royal British Bank against Tequan, and subsequently applied in Mahoney against the East Hollyford Mining Company. Now, the rule was simply to the effect that third parties or outsiders dealing with the company in good faith can assume that the internal regulations of the company have been complied with. And for that matter, third parties are not obliged to investigate whether the internal affairs of the company have been complied with. In other words, the general rule was that if you are a third party and you are dealing with the company through a director or through an officer or agent of the company, you did not have, as a general rule, bother yourself as whether the company by its constitution was doing the right thing, was following the procedures and so on and so forth. You did not really have to burden yourself with that. That was the general rule. But there was also a rule that third parties, that is outsiders of the company, are presumed to have constructive notice of contents of the documents of the company filed in the registry. You notice that when a company is going to be registered, you fill forms, submit so many other things to the registry of companies, and the company is eventually formed. So there used to be the rule that because the register of companies is it's open to everyone, it's a public department, anybody at all can go and do inquiries. So where there is information about the company held at the register of companies, it is presumed that you have constructive notice. In other words, if you want to know, you can know. There's a means of knowing, so you are deemed to know there's a constructive notice. But the rule was said not to be applicable to insiders. That is insiders like the directors, members in general meeting, officers and agents of the company dealing with the company. Of course, if you are an insider, you have a privileged position. You know the actual thing concerning the company. And for that matter, you always know. And you cannot say that yours is just a constructive notice. You actually have like an actual notice, so to speak, as it were. Now, this rule in the Tequan case, which was quite controversial and a bit nebulous, has been codified in our company's legislation, going back to the repeal at 179, and now the new one, the 2019 version at 992. So originally, under the common law rule, the rule known as the rule in the Tequan case was that third parties dealing with the company are deemed to have constructive notice of the contents of all companies' public documents filed at the company's registry. However, if you look at section 149, there has been modification of this rule. So section 149 of Act 992 is to the effect that, and I quote, except as provided in section 121 regarding particulars in the registrar of particulars of charges, a person shall not be deemed to have knowledge of any particulars, documents, or the contents of documents by reason only that those particulars or documents are registered by the registrar or referred to in any particular or document so registered, unquote. So section 149 of our Act 992 is telling us that the only documents which third parties, everyone dealing with the company, will be presumed to have knowledge of is information relating to security created over the company assets, such as fixed charge, floating charge, when we are discussing debentures. So those matters are addressed by section 121. Now, apart from particulars information relating to security interests created over the assets of the company, there is no requirement that third parties have no constructive notice of any other documents of the company. So you notice that section 149 has effectively modified the common law position. And if you look at the commentary on the predecessor provision of section 149, which is in pari materia, essentially the same wording as section 149, Gower in his report, Gower's commentary, he will render the comment that, quote, it is impossible for people to search the file before they have dealings with the company, unquote. In other words, you are trying to justify why Ghana modify the original common law rule. And now to say that apart from information relating to security interests created over the company assets, maybe like the fixed charge or floating charge in respect of a debenture or credit arrangement, like collateral arrangement, we do not expect that it is really practical for anybody who is going to deal with the company to go to the register of companies and check things before he or she will be able to do with the company. Were that to be so, it will be practically inexpedient to be doing transactions with the company. So that seems to be the raison d'etat or the rationale underpinning the modification which we have seen in our law per section 149. So if you look at the section 150, which I have already alluded to, that is section 150, subsection 1 of Act 992, it's similar to the common law position. And let's look at the section 151. If we read the provision itself, quote, a person having dealings with the company or with any other person who derive title under the company is entitled to assume that A, the company has been duly incorporated under this act. B, a person described in the particulars filed with the registrar pursuant to section 13 and 216 as a director, managing director or company secretary of the company, or represented by the company, acting through the members in general meeting, board of directors or managing director, or as an officer or agent of the company, has been duly appointed and has authority to exercise the powers and perform duties customarily exercised or performed by a director, managing director, or company secretary of a company, carrying on business of the type carried on by the company or customarily exercised or performed by an officer or agent of the type concerned. C, the company secretary and any other officer or agent of the company having authority to issue documents or certify copies of the documents on behalf of the company has authority to warrant the genuineness of the document or the accuracies of the copies so issued. Or D, a document has been duly authenticated by the company if it, one, or I bears what purports to be the seal of the company, attested by what purports to be the signatures of two persons who, in accordance with paragraph B, can presume to be a director and company secretary of the company, or II, is certified by what purports to be the signatures of two directors and the company secretary of the company, and the company and those deriving title under the company are stopped from denying the truth of that assumption, unquote. So, section 150, subsection 1 is effectively telling us that, as a general rule, when you are dealing with the company, you are entitled to make certain presumption, to presume that those who are directors are properly be appointed, to presume that all that need to be done before the company is incorporated were properly done, to presume that those who are appointed officers and so on, or company secretary, have properly been appointed. So those are the things you can take for granted when you are dealing with the company as a general rule. And this presumption of regularity is not novel and is not limited to only company law. As a matter of fact, if we look at the law of evidence in general, the law of evidence, you have come across the principle which you called omnia presumptio rite esse acta. That is presumption that, if you look at section 37 of the Evidence Act 1975, NRC 323, it is presumed that official duty have been regularly performed. So what we call the omnia presumptio rite esse acta, presumption of regularity of official duty. So just as if a police arrests you, you are not supposed to worry yourself as whether the person has properly been appointed as a police, whether the letter was signed by the Minister of Interior and so on, or when a judge has actually pronounced a judgment. You are not supposed to worry about whether the judge has actually been sworn according to procedure for no. And you are supposed to make presumption that those official duties are properly carried out. So it's the same thinking which is also deployed under section 151, that when it comes to the company, third parties can also presume that certain matters are properly done so that they don't have to worry themselves to ascertain before they deal with the company. And if you look at it, it makes sense, because if you're a third party and you are genuinely doing business with the company, why should you suffer because officers of the company or those in charge of the procedures of the company fail to do the right thing? Why should you bear that responsibility? So there's wisdom in how the law is actually crafted or calibrated in terms of section 151 of Act 992. So please, it is also important to note that even when it comes to maybe like somebody has forged the signature or somebody has stolen the seal of the company to do a private transaction, the company has suffered a loss. The company can actually sue the particular officer whose activity has actually occasioned a loss to the company. However, the company will still have to pay whatever money it has to pay to the third party. And having paid whatever is supposed to pay under the transaction to third party, the company can then come back home and find out whose officer, which official or which officer's conduct actually led to the loss which the company has to incur towards the third party. But the third party is protected. Yeah, so that is the point. So look at the case of Commodore against the Food Supply Ghana Limited, statement that that is Judge made, and Barclays Bank also against Perseverance. Now we have exceptions to the rule in the Tech 1 case. We have exception to the presumption of regularity, which we stated under section 150, subsection 1. That is the general rule, but there are important derogations or exceptions. In other words, there are occasions in which a third party or a person will not be allowed to benefit from presumption of regularity, as it were. So the rule of regularity will not avail a third party who has notice of the irregularity or the fact that the internal regulation of the company will not comply with. In other words, if there's evidence to show that despite being a third party, you had enough evidence, enough information for you to be cognizant, for you to be aware of the fact that the company had not done the right thing according to its internal regulations or constitution when it was dealing with you, and you were very much aware, but you decided to ignore it and told yourself that, after all, I'm a third party. Section 150, subsection 1 says that I'm entitled to make presumption of regularity, so why should I bother? Then you go ahead and do the transaction, despite the abundant knowledge and awareness that what the company was doing was not right according to its constitutions and all that. So where that is the case, then you will not be allowed to take advantage of it. And that is why if you are a person who have a relationship with the company, and by reason of your relationship, it is such that you know or ought to have known about the defect in the power or authority of the company's organs, officers, or agents, then you are stopped from trying to enforce any right or benefit which will have accrued under the transaction. So let us keep that in mind. And if you look at the section 150 subsection 2A, that is what it says. So section 150 subsection 2A and B. And then look at the case of Chelam and Sons against Halabi, and also Bank of New Zealand against Fiberi Limited. Now, we come to this question: can the company be liable for tort? Is it possible to hold the company in liability as far as tort is concerned? Especially, we know that the company is not a natural person, artificial person, and functions only through human beings or designated organs. So, the acts of these organs or officers or agents are considered the acts of the company if they are done in the usual way, in the ordinary course of business, as we saw in section 147 of Act 992. Now, where an organ of the company, be it the members in general meeting, board of directors, company secretary, or any officer or agent of the company, commits any tort in the usual course of conducting the affairs of the company, the company will be vicariously liable for the tort in question. Remember vicarious liability, where the employer or the principal is made to assume liability for acts or actions done by the employees, as it were. So I would like two ladies, two gentlemen, to give me examples of torts and justify why the company will be held liable in respect of that tort. So, yes, anybody raise up your hand. I'm releasing the mic so that you can talk. Yeah, so let's start with the ladies. Starting with the ladies. I'm a father of girls, so I have a bias for women. Oh, ladies, don't let me down. Yes. A gentleman's hand is up, but I want to hear the ladies first. That's why I've not called him. Ladies, I'll call you myself if you are not putting up your hand. Let me see the list. Okay, this Georgette, and Georgette must be a lady, isn't it? Georgette Dazi.
Sir,
Yes.
the employer's liability in tort. If an employee of a company or
Yes.
a business,
I'm teaching. Yes, go ahead.
okay, if an employee of a company uh, is liable for any crime in the course of his or her execution or in the course of his duty as an employee of the company, the person would not be sued, but the company will be sued.
All right. Okay, Georgette. But I wanted the substantive tort. You have told us about the vicarious liability. That is true.
Yes.
I want like the particular tort, which when committed, the company can be vicariously liable.
Liable.
Yes. Okay, so let Nathaniel. Okay, Elizabeth, your move is here. Elizabeth.
Yes, my lord. So I'll give an example. For instance, let's say an officer of a company is being, I mean, the company instruction is that you cannot drive a company's car and park and have lunch. So let's say this officer goes on an errand and park and have lunch, and probably the cost of parking before having lunch hit another car or cause an accident, someone dies. In this case, I think the company will be held liable because the officer is working, is on errands, is working in the course of business. So I think in this case the company likely to be held liable.
All right, thank you, Elizabeth. Now come to Nathaniel. Nathaniel J.
Okay, thank you very much, sir. Hello.
Nathaniel J, yes. What is your J for? Are you a high court judge already? Nathaniel, go ahead. We've lost him. Okay. And then if Nathaniel is lost, then let's take Brobe Emmanuel.
Nathaniel Jonah, Nathaniel Jonah, sir. Nathaniel Jonah. Yes, sir. Let me give a typical example. I will use first. Okay, I'll leave. Okay.
I think Nathaniel's line is not clear. So let's take Tijani Ibrahim or Brobe Emmanuel.
Hello, my Lord. So a typical example of thoughts that a company will commit is negligence.
Okay.
Negligence. So under negligence, there are 4 elements that must be proven. And the first element is duty of care. The second is duty of duty. 3 is the causation, and 4 is damages. And a locus classicus of a typical example of a case that a company committed is our very known case that you all know well, is Donogo versus Stevenson. You see, this is Donogo versus a cafe in Scotland, where a friend bought a bottle of ginger beer, and the ginger beer was in a big bottle. So it contained some elements that Mrs. Donogo was not able to see. And after drinking some of it, Mrs. Donogo discovered some decomposed milk in the bottle. He suffered some shock and some illness as a result happened. So a clear example that I can give that a company will be liable under a tort is, and the locus classicus I can also give is the logo versus Stevenson to establish my claim of negligence and tort that a company may also commit. Thank you very much, my Lord.
All right, thank you. Yes, Tijani Ibrahim.
Yes, my Lord. My Lord, thank you for the opportunity. Yes, a company can be held liable in torts, most especially when it has to do with product liability. Product liability in that a company works through its officers and members as espoused in Section 144. With these, where employees or officers work in line with their employment or their duties in the company, which results to a harm caused in the process of production, these, the company shall be held liable for the tort cost. Secondly, direct liability can also be used against the company when acts or omissions caused by employees or officers of the company causes a direct harm, which those officers should have known or foreseeably known using a reasonable man test, in that if they could have those people who were caused harmed in their contemplation, those harm would have reasonably not have been occasioned. With these, the company will be held liable, either vicariously or by strict liability in that regard.
Thank you. Reverend Francis
I'm most grateful.
Ampunsen, the last contributor, and move on. Yes, Reverend Francis Ampunsen.
Thank you very much, my Lord. Please, I'm also looking at a thought like nuisance, where in a company, for instance, if a company's factory causes excessive noise or pollution that interferes with the use and enjoyment of, let's say, nearby properties, that may also result in a direct thought of nuisance. That is my thought.
Yeah, thank you. Thank you very much. Well, let's say if you take like newspapers, right? Daily Graphic, Crusading Guide, the Statesman, just name them, the Catholic Standard. These newspapers are often incorporated as a company, but you know, the company is artificial person, where the editors and then the various staff that work on it, they defame people by libel. Yes, the company will be held vicarious or liable, because the company owns the means of publication. Now, what about liability of companies for crimes, for criminal offense? A company can be liable for crimes, and for that matter, prosecuted in criminal proceedings for its acts. So, as a general rule, for a company to be fixed with a crime, there must be proof that the act constituting the crime was committed by the company itself. And when we say by the company itself, that is by the organs or its responsible officers. So if it's the directors who did that, or officers, any officer of the company which did that, or members in general meeting, that will be treated as the act of the company. Now let's look at section look at section 2 of the Criminal Offences Act 1960 as amended Act 29. For example, it will say that, it will tell us who, like that a company includes partnership or association, whether corporate or incorporated, and whether the purposes are or are not carried on, and so on. Then subsection 2, that is section 2, subsection 2, a company is in the course of formation as soon as an act is done for the purpose of forming it, and it is immaterial whether or not it is at any time actually formed. Then to tell us, officer includes, when we say officer of company, what it includes for purposes of holding the company criminally liable. So officer includes an auditor, accountant, officer, chairman, director, trustee, manager, secretary, treasurer, or any other person provisionally, permanently, or temporarily charged with the duty of performing a function in respect of the affairs of the company or corporation, whether for or without remuneration. Yeah, so the company can be held liable for a crime if it was committed by the officer or the agent. And as you notice, it's not the company itself as a principal which is being held liable for the crime committed by its agents. No. As you notice, in criminal law, the principle of vicarious liability does not apply in criminal law, isn't it? You don't hold someone vicariously liable for. So your employer has sent you, you've committed a crime, and you expect your employer to be held liable. No, that is not how it works. So the company is not held liable for the crime just because it is the principal, and then the officers are its agents. No, that is not how it is. Because you know that for purposes of mens rea and all that, we cannot ascribe the mental guilty state of the man or of the agent to that of the principal, as it were. But because the acts of the organs or the officers are considered as acts of the company, according to what we'll be discussing under section 144 and other provision. That is why we are holding the company criminally liable, and not just because of the principles of general agency law. No. So look at the case of Tesco supermarkets against Nataras. And Lord Diplock will give a very important teaching on circumstances for holding a company criminally liable. And also the case of a Belmont Finance Corporation against Williams Furniture Limited. There is also a case, but the case is still sub judice, so I won't talk about it. There's an aspect of it in which the criminal liability of the company was also discussed. Now, the company may also be convicted of manslaughter. Certainly, the company cannot be convicted of murder, as you know, but can be convicted of manslaughter. Of course, when it comes to contempt, the contempt of the company will be enforced against its officers or officials. And if you look at Muntie 3, in Ray, owner of the station, Muntie FM and others, we saw how contempt against the media company was actually punished on the directors of the company, as it were. And of course, the case of the Deep Sea Division of National Union of Seamen and others against the Trade Union Congress of Ghana. Over there too, Justice Cecilia Kwantenado also gave important teaching on how contempt of a company will be enforced against its officers or officials. And of course, look at the case of Abu Ramadan and another against the Electoral Commission and another. Now, a company can also be a victim of a crime. The company can also be a complainant in a criminal offense. And it happens all the time. If you look at most of the offenses relating to stealing, dishonestly receiving, falsification of accounts, and forgery, oftentimes you notice that the company is the complainant. So note the case of R against Filippo, because of R against Filippo. Okay, so this will mark the end of discussion of the various civil liability and criminal liability which may be brought against the company.